Hello Realtors, welcome to another edition of The Walk To, your deep dive into the forms and contracts that power your business. I'm Byron King, Chief Legal Officer for South Carolina Association of Realtors.
And I'm Tiara Pitts, Ethics and Legal Compliance Officer for SCR. Today we are taking an in-depth look at the March 2026 update to SCR Form 220, our exclusive right to sell agreement.
Before we dive into the new SCR Form 220, we must begin with a critical reminder regarding antitrust laws. Real estate commissions, fees, and the terms of service are not set by law, nor are they fixed, controlled, or suggested by the South Carolina Association of Realtors, any local board, or the Multiple Listing Service.
Exactly right, Byron. All compensation is strictly a matter of independent negotiation between a broker and their client. In this video, we'll explain how this form functions, how to fill it out, but we will not discuss specific commission rates or standard fee amounts. To do so would be in violation of antitrust regulations. Our goal is to ensure you can explain your firm's independent pricing policies to your clients with confidence.
Today we're looking at the March 2026 version of Form SCR 220, the exclusive right to sell listing agreement. This is the foundational contract that establishes the agency relationships between the property owners and the listing brokerage.
So let's jump right in. Sections 1 and 2. The first page of the contract identifies the party and the specific real estate being listed. Pay close attention to the length of agreement in Section 2. This is where you define exactly when your authority to market the property begins and ends. Section 3 goes into agency disclosure. This section confirms that the owner has received the required South Carolina disclosure of real estate brokerage relationship forms, which is an LLR form. It also provides space for the owner to initial their permission or lack thereof for dual or designated agency.
This is where you're going to write simply the price at which the owner agrees to market the property in the listing agreement.
Next is Section 5, Listing Broker Compensation. Here you will record the agreed upon fee that you are charging your client to list their property. As you'll note on this form, this will only have your fee as the listing agent and will not cover any fees to any buyer's agent or co-ops between yourself and a buyer's agent company. Also note that it has a protection period built in. This protects your commission if the property sells shortly after the agreement expires to a buyer you introduced during the listing term. Now I'm going to turn it over to Byron to cover Section 6.
Yeah, so Section 6, this is one that we've added to cover when there's unrepresented buyers. So you may be a listing agent and you have a buyer that comes to you via your yard sign or through your advertising. So Section 6 is where the owners can agree to pay you an additional amount of money. So Section 6 is your additional compensation for unrepresented buyers.
Section 7 is buyer broker compensation. In this section, it explicitly states a listing broker is not authorized to compensate any other buyer broker. Owners can choose to directly negotiate compensation using Form 120 directly with a buyer's agent. However, we will no longer have Form 120 between listing company and buyer's brokerage company. Now, Section 8 is owner concessions. This is where we distinguish between compensation, paying the agent, and concessions, helping the buyer. This form reminds sellers that concessions are fully negotiable, but don't forget to check the box. You'll see a box where the owner agrees or does not agree to allow the listing broker to advertise their willingness to negotiate concessions. Why check yes or no? Checking yes gives you permission to advertise the seller is willing to consider concessions in your marketing, which can be a huge green flag for cash-strapped buyers. However, checking no can be a smart negotiation tool in a hot market because why advertise concessions when you expect to receive multiple offers? Choose wisely, know your market data, and remember to always keep your client's best interest first.
Section 9, earnest money. This designates the escrow agent to hold the deposits and specifies the funds cannot be released during a dispute without a signed agreement or court order.
So, Byron, can earnest money be released in the case of a seller inaccurately filling out a property disclosure statement?
Yeah, so any kind of dispute, legal dispute, arguing somebody's in breach of contract, the hotline's going to recommend that the parties, SCR offers mediation to try to handle the dispute. Otherwise, the parties will need to hire their trial lawyers and litigate the action to find out who's in breach of the contract, and that would determine damages and attorney's fees and the earnest money, how that would be divided.
Exactly. And if you have any questions, of course, call the legal hotline. Next, we're moving on to Section 10, signs. This just gives the broker permission to put real estate related advertising signs in the owner's yard or property, and that is pretty self-explanatory. But for example, for sale signs, under contract, or even sale pending signs.
Broker liability protection. This section protects and limits the liability of the broker unless the broker acts in grossly negligent manner.
Section 12 and 13 go over the broker and owner duties. It lists the broker's commitment to marketing and the owner's duty to provide reliable information, allow for inspections, and refer all inquiries to the broker.
Section 14, residential property condition disclosure. This emphasizes the seller's legal obligation to disclose material defects. It also includes an important indemnification clause protecting the broker from claims arising from seller omissions.
Section 15 is lien disclosure. This states that an owner that's aware of any liens on the property must make that information known to their broker and to the closing attorney when appropriate.
Section 16, taxes. It says the parties are going to pay their required income taxes in the state of South Carolina and federal income taxes as required.
Section 17 is the Coastal and Tidelands Wetlands Act. If your property is affected by the provisions of that act, then it will be attached to this agreement and incorporated with any required disclosures under the act.
Yeah, that'll be Form 391. 18, multiple listing service public marketing. This is where the owners are going to initial one of these two options. The owner must choose whether the property will be entered into the MLS is kept as a broker exclusive. Note the warning in option 2, limiting exposure can impact the final sales price.
Section 19 is going to be your lockbox section. It's going to grant the broker permission to place a lockbox on the property for showings.
20, other offers. The owner understands the broker's responsibility to present offers from others is terminates at closing, subject to the expiration of this agreement, whichever occurs first.
Section 21, you're going to hear this a lot. Commission and fees are not set by law. We have that in several places throughout our contracts and our training because we really want to stress the importance of contracts being fully negotiable and not set by any laws.
22, marketing the property after accepted offer. The broker shall not continue marketing the property after an offer has been accepted as requested in writing by the owner to do so.
Section 23, maintenance. This section says that the owner has to maintain the property. This includes things like the lawn until closing and also maintain all heating, air, electrical, and plumbing systems up until closing.
Section 24, agreement to sell. When the buyer is found for the property, the owner will enter into the agreement, which has all the terms of sale, customary provisions about examining title, curing any title defects, appropriation of taxes, and applicable property expenses.
Section 25, our lead paint disclosure section. If the property is built before 1978, a lead paint disclosure must be signed and attached to this agreement.
26 says parties are going to mediate before they litigate.
27 is our fair housing section of the contract. An owner cannot discriminate based on protected class categories, and neither can you as the agent. You can also not facilitate a transaction where an owner is attempting to discriminate based on protected classes.
28, digital communications delivery. This says that all these transactions can be conducted electronically. SCR provides you forms through all the vendors, the 5 major vendors.
29, enforcement. This section adds a little bit of teeth to the contract and allows the broker to fully enforce this contract. It also states that the owner will indemnify any costs related to enforcing this contract on behalf of the broker.
Sex offender criminal information. The owner agrees the broker is not responsible for obtaining or disclosing sex offender registry information. If parties are interested in sex offender registry information, they contact the sheriff and go to the South Carolina Law Enforcement Division website that's stated here in Section 30.
Sections 31 and 32 deal with photography and surveillance. These sections grant you the right to use marketing photos and reminds the owner to follow all laws regarding audio and video surveillance during showings. Also, everything's being recorded. Everyone has a Ring doorbell, so be careful when going to showings about the things that's said inside of properties.
Section 33 is talking about any amendments going to be in writing and properly executed by the parties to be enforceable.
Section 34 handles fraud. There is wire fraud, land scams, all kind of fraud involving real estate. This section states that before wiring any funds, please contact your closing attorney and make sure you're following the appropriate directions for wiring funds.
Section 35, other terms and conditions. This is for when your brokerage has lawyer-approved phrases, or you contact the hotline and talk to me or Tiara at the legal hotline to get some language to add into Section 35.
In reference to that section, Byron, would you recommend agents writing in clauses or even crossing out things out of this standard agency agreement?
Yeah, so this is a legal agreement. There is some risk of somebody accusing you of unauthorized practice of law, which is a felony, ethics violation, license law violation lawsuits. Our recommendation is to only use sentences and phrases that have been approved by your broker in charge and your brokerage attorney, or you call the hotline and talk to Tiara or myself or Nick Cromitis.
Thank you. And that wraps up our walkthrough of the new Form 220. Remember that this is a legally binding contract. If your clients don't understand a section, they should always seek legal counsel before signing. If you don't understand a section, you have your SCR legal team here to assist you. The legal hotline is open Monday through Friday. Our phone number is 803-772-5206.
Yeah, and just to remind you about that Section 35, we get a lot of hotline calls on 35. We have to issue a very important warning on the unauthorized practice of law. So as a realtor, you're authorized to explain standard language in these forms and fill in the blanks to reflect the intent of the parties. But it's an unauthorized practice of law at risk, so you're not authorized to draft original legal language. Make sure you get your brokerage attorney, your broker in charge to sign off on the language. Call the hotline. Never provide legal opinions on title. That's a lawyer's job. Never give advice on the legal consequences of breach. That's a lawyer's job. When you call the hotline and we say the parties have to hire trial lawyers, that's what we're talking about. You can't give them advice on who's in breach and who's not on breach. They need to hire their own attorney. SCR does offer mediation. If mediation fails and they can't work it out, they may end up in court.
We hope this edition of the walkthrough helps you navigate Form 220 with your clients. Remember, these forms are designed to protect both the consumer and your brokerage, but they only work if they are filled out accurately.
I'm Byron King. Thanks for watching. We'll see you in the next training session.
And I'm Tiara Pitts, and this has been a pleasure walking through this form with you.